Hello everyone. When a person is sentenced to death, the court has to decide the punishment. But that decision immediately leads to another important question. How should that punishment actually be carried out? That is a question that has now come before the Honorable Supreme Court of India in a challenge to hanging as a method of execution. Here the petitioner argued that hanging violates the right to dignified death under Article 21 of the Indian Constitution, and their argument was based on a simple concept. The petitioner argued that if the Constitution protects the human dignity, should that protection continue even when the states carried out a death sentence? The Honorable Supreme Court has now considered that the question and upheld the constitutional validity of hanging as a method of execution. But to understand why the court reached this conclusion, we first need to understand the earlier cases that has been at the center of this debate. The first case that I want to discuss with you all in this lecture is Dina versus Union of India case, which was decided in 1983. The case involved a challenge to hanging as a method which was used to carry out a death sentence. The question before the Supreme Court of India was, does hanging violate Article 21 because the method could cause unnecessary pain, suffering or degradation? So to answer that question, the Supreme Court of India examined different medical evidence, expert opinions and the way the long drop method of hanging was carried out. And finally, the Supreme Court of India found that the drop was calculated according to the factors such as person height and his weight. The purpose behind the purpose was to cause a fracture of dislocation at the C2-C3 vertebrae resulting in the near instant of senseless. Based on that evidence available at that time, the Supreme Court of India concluded that a properly administered hanging was a quick method of execution and which did not involve a greater pain than the other available methods. And they also upheld that when it's carried out properly, the method did not amount of torture or degradation. That decision became an important legal foundation for hanging in India. And that is exactly why the present challenge was a significant one. Here the petitioner were importantly asking the Supreme Court to reconsider that 1983 conclusion in the light of newer scientific evidence evidence and the evolution of constitutional principle that was surrounding the human dignity. So the court was not starting a debate from zero. It was being asked whether the reasoning adopted in the Dina versus Union of India case more than 4 decades ago should now to be reconsidered. And that is where the petitioner brought a new scientific evidence. They referred to a 1992 study which was involving 33 people who had been hanged in England in between 1882 and 1945. The study found that although the C2-C3 fractures were common, the scientific injury known as hangman's fracture that was associated with the near instant death that was occurred only of 3 of those cases, and 6 people in this study died from suffocation. And other important finding that was raised a crucial question. The result of hanging can be varying depending on the drop. Can the method really be described as a constantly quick and controlled? Here the petitioner argued that it could not. The drop that was too short could result in a strangulation, but the drop that too low could cause a decapitation. So their argument was not simply that hanging is an old method. Their argument was that the method of execution must also satisfactory to the modern constitutional standard of dignity and predictability. And once that argument was connected to the Constitution, Article 21 of the Indian Constitution naturally come into the picture. We know that Article 21, which was protect the life and personal liberty, over the years the Supreme Court of India has also connected Article 21 with the different human dignity that we can say that Article 21 is a subset of a human rights. That principle become particularly important for a case. Other case I want to discuss here is Jain Kaur versus State of Punjab, where the court recognized the idea of living and dying with the dignity. So the petitioner argued that even when the states carries out the death sentence, the penal process must protect or respect the human dignity. But while the petition relied on the newer science, means scientific evidence involving the constitutional principle, the court also had to look something equally important, that the law that is currently in force. We know that there is under section 393(5) of BNS, a person is sentenced to death is to be hanged by the neck until death. And this provision is entirely new. It is substantially continue a legal position that existed in the Criminal Procedure Code as far back as of 1861. That continuity becomes important because Parliament recently had an opportunity to change this position. When the Parliament enacted BNSS, it chose to retain hanging as a prescribed method of execution. So the Supreme Court was forced with the two important considerations. They faced with the two important considerations. On one side was the Dina judgment, which had already upheld the hanging. On other side was the Parliament decision to retain the same method in the new criminal procedure law. That means the petitioner had to show that something fundamental had changed since 1983. The question therefore became very specific. Had a new scientific evidence and the evolution of constitutional law become strong enough to overturn the earlier judgment? The Supreme Court of India concluded that they had not. The bench found that new material did not fundamentally displace the basis of Dina judgment, but that still left another question. If the hanging is not being replaced, are there other methods that could provide a better alternative? That takes us to the recommendation of a law commission. The law commission, the 187th Law Commission report of 2003, that was chaired by Justice M. Jagannath Rao, had recommended amending the law to provide a lethal injection as an alternative method of execution. Here, the report also noted a military court-martial permit execution by shooting. So, alternative had already been considered, but there is an important distinction here. A law commission recommendation is not the same as change in law. It remained recommendatory until Parliament decided to act on it. And when the Parliament enacted the BNSS, it chose to retain hanging. The legislative decision therefore reinforced the existing legal position. The Supreme Court of India also considered whether alternative methods were clearly superior. The petitioner referred to the methods such as lethal injection, electrification, lethal gas and shooting, but the court found no sufficient basis to conclude that these methods offer a clear advantage over hanging. And that is why the Supreme Court of India ultimately upheld the S60 method. It referred that the long drop method of hanging, when properly administered, satisfied the state obligation to carry out the death sentence with the deficiency and decorum without the degradation or brutality. But there is an important point here that should not be missed. The Supreme Court of India has not said that this question has never raised again. Instead, it recognizes that constitutional law evolves. So, if future scientific or empirical evidence of fundamental change, the assumption behind Dina, a future challenge, could still be considered. The Supreme Court of India also felt it open for the Union government to examine alternative method of execution if they choose to do so. In other words, the Supreme Court of India upheld the hanging today without saying that debate must end today. And that is the difference is important because the law may remain the same for now while the constitutional debates that continue. This debate is also taking place much larger global context. Around the world, the countries that continue to use the capital punishment that employs the different methods. Hanging remains a method which was used in the countries such as India, Singapore and Japan, and lethal injection now used in several US states and in China. And the other method called the shooting is used in countries like China, North Korea and Somalia as well as part of the West Asia. Beheading is practiced in Saudi Arabia. And there is another, is called the nitrogen hypoxia, has emerged more recently as another method in United States. But the existence of different methods does not mean that the larger problem has been resolved. Each method comes with its own concern. The lethal infusion, for example, has faced criticism because problems such as failed execution and difficulty in securing the proper vendor success. The nitrogen hypoxia has also been criticized because it was relatively new and insufficiently tested method. So the debate is not really about the finding one perfect method. It is about a much larger constitutional question. If the state has the power to impose a death sentence, what the limit should govern the manner in which that sentence carried out? That question becomes even more significant when we look at a broader global trend. Two, Two-thirds of the countries have abolished the death penalty in law or practice. At the same time, execution increased globally in 2025. This contrast shows why this debate continues. While many countries are moving away from the capital punishment, others continue to debate how execution should be carried out, and that is where the Supreme Court later decision fits in. The Supreme Court has to maintain the existing legal position rather than overturn it. At the same time, it does not close the door to the future scientific evidence or legislative change. So for now, hanging remains the constitutional validity method of executing a death sentence in India, but the larger question of dignity, humanity, and the future of capital punishment remains open to the debate. And perhaps that is the most important takeaway from this judgment. The court has upheld the existing method, but it has also acknowledged that constitutional law can evolve when new evidence and new understanding emerge. So the judgment represents a balance between the legal continuity today and the possibility of human reform tomorrow. Thank you for so much to watching. See you in next video.